Ruth Bader Ginsburg, before she was Justice Ginsburg, was an advocate for sex equality, not just for women's rights, but for a certain vision of sex-based equality. She did this by bringing cases on behalf of men who had been discriminated against on the basis of their sex. She had the view that the judges would have a better ability to grasp or maybe relate to a concept of sex-based equality if they could see it as something that men experienced as well. She brought that vision to the Supreme Court in her 1996 opinion in the Virginia Military Institute case, where there was a challenge by a young woman, Shannon Faulkner, of the VMI's rule that they would only allow male cadets, male students at VMI, and she wanted to be a cadet. She wanted to go to VMI and get a military, very strict education, and she won. In that case, and this is a quintessential Ruth Bader Ginsburg opinion, she says neither the goal of producing citizen soldiers nor VMI's implementing methodology is inherently unsuitable to women. Generalizations about the way women are,
estimates about the way most women or most men are, will not suffice to deny opportunity to women whose talent and capacity place them outside the average description.
One of the other just wonderful things that Justice Ginsburg brought to the court was a very self-conscious role of educating other members of the court and the public about what sex-based inequality looks like. It's very similar to the role that Justice Thurgood Marshall played on the court of educating the white male members of the court. Justice Ginsburg did the same thing, and two cases I think illustrate this very well. The Lilly Ledbetter case from 2007 is a case in which Ms. Ledbetter worked for Goodyear Tire and Rubber Company. She learned after some period of time that she was being paid substantially less than comparable men who worked for the company. But when she discovered this, the pay inequity, sex-based pay inequity, the statute of limitations for filing a claim under Title VII, the federal law that prohibits sex-based discrimination, had already expired. That question was litigated out to the Supreme Court of should the clock start ticking when the discrimination starts or when you learn of it. The Supreme Court ruled against her and found that no, the clock starts ticking when the discrimination starts, and if you learn about it later, oh well, you know, you've lost your chance to challenge it. And Justice Ginsburg did something that is just quite remarkable. She issued a very stinging dissent in the decision, but she also issued a version of her opinion for public consumption that removed all the technical legal reasoning, but actually explained for a regular lay person what was wrong with wage-based discrimination in the workplace and how common it was. So she wrote,
"Pay disparities often occur, as they did in Ledbetter's case, in small increments. Only over time is there strong cause to suspect that discrimination is at work. Comparative pay information is not routinely communicated to employees. Instead, it is often hidden from the employee's view."
This is how sex discrimination works, she says, not in some technical way that the law, some might anticipate, or that the majority just found, but it actually works in the absence of information available to the person being discriminated against. And that's how workplace inequality persists and reproduces itself. The court's 2013 Shelby County versus Holder case, a case in which the court affirmed the suspension of a kind of review that was built into the Voting Rights Act of state practices that had shown themselves historically to deny voting rights largely to Black people. And the majority of the court released them from that kind of supervision. She wrote, and this is just such beautiful language, "Throwing out pre-clearance," which is that process of review, "when it has worked and is continuing to work to stop discriminatory changes is like throwing away your umbrella in a rainstorm because you're not getting wet." If there were one thing to say about Justice Ginsburg and her impact, it would be her laser focus on a particular vision of the kind of world she wanted to live in, largely because she had experienced it and its inequality and injustice so personally.
Every time I write a dissent, I'm hoping for one result, either congressional change or the other, that the court will overrule its prior wrong decision. Who is it who said that it ain't over till it's over?